All right. Hey, everybody. Hopefully, this is coming through because I signed into the wrong account on my live feed because I haven't done one in a while. So let me know if you all can see or hear me before I get too far into this. Let's see. Boom, 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 boom. I will wait for some quick comments and I will try this as well. Mute. All right. 5x5. Sweet. Awesome. I already see a delay in the comments, so bear with me. I'm doing this live, honestly, guys, because I just don't want to edit anymore today. It's been a long day. I worked on my car for about 6 hours today. I am going to jump right into it. We have a victory, another victory in the the Vanderstock decision. It's the Jennifer Vanderstock case. I'm going to put it on the screen right quick here. If I can get this to share my screen without blowing up. Okay, I'm going to do this one. Share. Boom. All right, so let me blow it up so we all can see a little bit better. I think that's good. Okay. So, frames and receivers rule, ATF, violated the Constitution by trying to make law. Just like I did the video this morning on them being smacked in the teeth on the pistol brace rule, we now have a national injunction in pistol braces that will be appealed. We now have another kick in the teeth for the ATF today on frames and receivers. As you can see on your screen, this is the Jennifer Vanderstock, Michael Andren Tactical Machining, a Firearms Policy Coalition, along with Black Hawk Manufacturing, doing businesses 80% Arms, Defense Distributed, Second Amendment Foundation, and JSD Supply, as well as Polymer 80 versus Merrick Garland and Stephen Dettelbach, who is the two dipshits. One's the Attorney General, the other one's the ATF Director. All right, let's jump into this. I have not had a chance to read it. It's 58 pages, but I did read a couple bits of it. Sorry. Put this on. There we go. Did read a couple bits, but it made me smile, so I figured y'all want to see it together. This is a 3-judge panel. Okay, you can see the judges there: Willett, Engelhardt, and Oldham. And this is what Engelhardt said. This is good stuff. It has long been said correctly that the law is an expression of legislative will. Thank you, Sergeant Willie. Appreciate you. As such, the best evidence of the legislature's intent is the carefully chosen words placed purposefully into the text of a statute by our duly elected representatives. Notice, not the ATF. Critically, then, lawmaking power, the ability to transform policy into real-world obligations, lies solely with the legislative branch, where an executive agency engages in what is, for all intents and purposes, lawmaking. The legislature is deprived of its primary function under our Constitution, and our citizens are robbed of their right to fair representation in government. This is especially true when the executive rule turned law criminalizes conduct without the say of the people who are subject to its penalties. Real quick, thank you to Blackout Coffee for making this live stream possible. I am running on Blackout Coffee right now. Guys and gals, blackoutcoffee.com/GNG. Coffees, loose leaf teas, hot chocolate, tons of flavors. Use code GNG10 to save 10%. blackoutcoffee.com/GNG. Links down below. Let's continue. The agency rule at issue here flouts clear statutory text and exceeds the legislatively imposed limits on agency authority in the name of public policy. Joe Lover Street, thank you very much. Because Congress has neither authorized the expansion of firearm regulation nor permitted the criminalization of previously lawful conduct, Ballistic Squeeze, thank you. Whiskey, it will be coming right after this video. Thank you so much. The proposed rule constitutes unlawful agency action in direct contravention of the legislature's will. Accordingly, for the reasons set forth below, we affirm in part and vacate and remand in part the judgment of the district court. Now, The statutory and regulatory background, we know this. We know the rule that has been put in place by the ATF because Joe Biden wants them to ban everything possible administratively. Unconstitutional, yes, administratively. Let us jump to, I will link this decision down below. This was sent to me by a few people, but Firearms Policy Coalition had it immediately because this is their case. Let me jump down. I want to show you what another judge said. This is going through the previous cases that this case has been going on long term. We'll go to the analysis. The plaintiffs challenged two portions of the final rule in the underlying lawsuit. One, ATF's proposed definition of frame or receiver, including incomplete frames and receivers. And two, ATF's proposed definition of firearm, including weapon parts kits. Derek of all trades, thank you. Joel Cutler, thank you. I appreciate all of your support. Fellow TriStar resident, please say plainly, it's the brace rule over. Is the brace rule over and in favor of gun owners? Brace rule is over right now. It's going to be, it'll be appealed, but the rule has been stayed in its entirety for everybody across the country. Okay, so ATF's proposed definition of firearm, including weapon parts kits. We analyze each challenge portion of the final rule in turn below before addressing the appropriate relief should these specific portions of the final rule be held unlawful. Frankenstein Firearms, thank you. I trust the First Strip Media Strip Club more than I trust the ATF. Yeah, that's good. At the outset, we must ensure that we look through the proper lens when analyzing ATF's actions here. It is axiomatic that an administrative agency's power to promulgate legislative regulations is limited to the authority delegated by Congress. Blah, 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 blah. In the Gun Control Act, in the GCA, the source of ATF's capacity to promulgate the final rule, Congress delegated authority to ATF through the Attorney General to prescribe only such rules and regulations as are necessary to carry out the provisions of this chapter. Such a grant of authority from the legislature to an executive agency is generally policed by the Administrative Procedure Act, which allows courts to set aside agency action found to be, among other things, in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. Thus, a core inquiry in a case such as this one is whether the proposed agency rule is a lawful extension of the statute under which the agency purports to act, or whether the agency has indeed exceeded its statutory jurisdiction, authority, or limitations. Okay, so you get the jux of this right here. You get the gist. Frankenstein Firearms, thank you very much. Trump and Ramaswamy. That would be a cool ticket. I don't know if Trump would ever do that though. We already know the proposed definition. We know that it's changed, that the ATF is just changing definitions left and right, and they don't have the authority to do that. We know that. Let me get to the next section I wanted to show you. Sorry about the scrolling, guys. I'm beat. David McGibbons, congrats on getting out of Massachusetts. I'm trying to do the same. Do it. Trust me. Just do it. Do whatever you can. Get the hell out. I wanted to show you what another judge was talking about here. Okay. ATF finds its primary justification for regulating weapon parts kits in the designed to or may readily be converted to language in the Gun Control Act's definition of firearm. The government argues that the statute captures any item or items that may be transformed or changed into a working firearm based on the dictionary definition of convert at the time of the Gun Control Act's enactment. Funny, they don't want to go to the text history and tradition of guns, right? But they want to use the actual definition at the time of the Gun Control Act here. Can't have it both ways, Biden. Can't have it both ways. Because weapon part kits allow individuals to convert various parts into an operational firearm, the government argues the final rule's proposed definition falls clearly within the GCA's ambit. But this stretches the words too far. The government wants the word convert to be all-encompassing, such that any process or procedure that could ultimately lead to a finalized firearm can be regulated under the Gun Control Act's language. The language, however, is much more precise than that. In fact, the government's emphasis on the word convert ignores the surrounding words. The Gun Control Act does not just regulate anything that can be converted. Joe Usling, thank you very much, man. Appreciate you. Or to use the government's proposed synonym, transformed, into a firearm, but rather regulates any weapon that may readily be converted into a functional firearm. The phrase may readily be converted cannot be read to include any objects that could, if manufacture is completed, become functional at some ill-defined point in the future. Frankenstein Firearms, thank you very much. I trust my ex-wife more than the ATF. I trust your ex-wife more than the ATF. This would strip the word readily of its meaning, revert the Gun Control Act to its prior articulation in the FFA, and allow for regulation of weapon parts generally, which, as we have seen, was not Congress's intent in passing the Gun Control Act. Look no further than the words ATF used in the final rule's proposed firearm definition. It includes weapon parts kits that may readily be completed, assembled, restored, or otherwise converted to expel a projectile. Reading converted in conjunction with other listed verbs, completed, assembled, restored, we can see that the definition itself contemplates less drastic measures than the full transformation actually required by these parts. So the judges are killing ATF on their own wording here. The government's attempt to use the word convert to justify its unprecedented expansion of the Gun Control Act thus collapses upon a cursory reading of the text. So they're getting destroyed, okay? The judges are saying you don't have the right to do what you're doing. It goes over the public policy concern. We don't care about the public policy because it's text, history, and tradition. The remedy. We now turn to the appropriate remedy. The government argues that the district court's universal vacatur of the entire, of the entire final rule, not just the two challenged portions, was overbroad, regardless of the merits of the case. Michael Roach, thank you very much. Adam Pelkey, thank you very much. I appreciate you. Okay. While this court's precedent generally sanctions vacatur under the APA, we vacate. I'm going to say it again. We vacate the district court's vacatur order and remand to the district court for further consideration of the remedy, considering this court's holding on the merits. Conclusion. So what does that mean? It means we don't agree with the court saying that the vacated part is overbroad. Okay. Conclusion. ATF, in promulgating its final rule, attempted to take on the mantle of Congress to do something with respect to gun control, but it is not the province of an executive agency to write laws for our nation. That vital duty, for better or for worse, lies solely with the legislature. Only Congress can make the deliberate and reasoned decision to enact new or modified legislation regarding firearms based on the important policy concerns put forth by ATF and the various amici here. But unless and until Congress so acts to expand or alter the language of the Gun Control Act, ATF must operate within the statutory text's existing limits. The final rule impermissibly exceeds those limits, such that ATF has essentially rewritten the law. This it cannot do, especially where criminal liability can, and according to the government's own assertions, will be broadly imposed without any congressional input whatsoever. An agency cannot label conduct lawful one day and felonious the next. Yet that is exactly what the ATF accomplishes through its final rule. Boom. Owen, thank you very much. Accordingly, the judgment of the district court is affirmed to the extent it holds unlawful the two challenged portions of the final rule and vacated and remanded as to the remedy. The frames and receiver rule is gone for now. It's not at the final step yet, but it's gone right now. This is great. All right. So here's another judge's opinion who is concurring. I believe this is a 3-0 ass whooping. Oldham. I join my esteemed colleagues' majority opinion without qualification. I write only to explore additional problems with the final rule promulgated by the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Part 1 provides additional background. Part 2 discusses ATF's unlawful conflation of two fundamental different statutory regimes. Part 3 addresses the weapon parts kit provisions, and Part 4 considers the unfinished frame or receiver provisions. So this talks about the old rule, which was the 80% rule, blah, 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 blah. Again, I'll link this down below. This judge uses ATF's own submitted photos against. 1, 2, it's still part 2. Boom, boom, boom. Let's see, the last judge, I wanted to show you what he said. Come on, ATF's crap. This is phenomenal. Are you guys excited? Like, in the comment section, say hell yeah if you're excited about the constant ass whooping the ATF's been getting, and it's going to continue. Text, history, and tradition. Bruin for the ATF was a son of a bitch. But for America was a step towards the way it should have been all along. This is the hamburger part I wanted to read. Let's read this C section here. Let's close with the ATF's eye of the beholder statement. As noted in the previous sections of this opinion, dictionaries define frame and receiver like the old 80% rule in terms of critical components, parts, and functions. For example, the frame or receiver must be able to hold a trigger or a breech block, or it must have certain parts milled, etc. In the place of these standards, ATF said metal or plastic is a frame or receiver if it has reached a stage of manufacture where it is clearly identifiable as an unfinished component part of a weapon. Or rather, once an ordinary person can look at an object and say that it looks like an unfinished component part of a weapon, it has become a frame or receiver within the meaning of 921A3B. How does this interact with ATF's assertions throughout the final rule that it now regulates anything machined beyond primordial ooze and liquid polymer? Unclear. What does clearly identifiable mean? Clearly identifiable mean? Also unclear. What objects do ordinary people who might associate receivers more readily with footballs than guns think are clearly identifiable as firearm components? Yet again, unclear. Sorry, trying to catch up. We all know that ATF, like Justice Stewart, is confident that it can identify a Gun Control Act firearm when it sees one. ATF's problem is that 921A3B covers objects that are firearms and receivers, not objects that look like frames or receivers. A recent internet fad illustrates the point. Consider the cakes that look like food, the internet trend. Okay, that refers to a YouTube video. One could make a cake that looks like a hamburger, just as one could make a cake that looks like a gun frame or receiver. One is clearly, Ryan, thank you so much. One is clearly identifiable as a hamburger, just as the other is clearly identifiable as a gun part. But that does not make the former taste like a Big Mac, just like it does not make the latter covered by the Gun Control Act. The judge just kicked ATF in their balls. Just because it looks like something, it doesn't mean that it is. The final rule is limitless. It purports to regulate any piece of metal or plastic that has been machined beyond its primordial stage for fear that it might one day be turned into a gun frame, or a gun receiver. And it does not stop regulating the metal or plastic until it's melted back down into ooze. The Gun Control Act allows none of this. I concur with the majority's opinion holding that final rule is unlawful. And I further concur that the matter should be remanded to the district court to fashion an appropriate remedy for the plaintiffs. Boom. Guys, they just kicked the ATF's ass over the frame and receiver rule. And this makes me smile. It's been a long day. I have busted up knuckles, tweaked my back, working in my car, trying to update a few things. I just sat down and said, man, I'm done. Time to take some Advil and a couple shots of whiskey. And then this happened. So I decided to go live so I didn't have to edit. But I hope you all are feeling it just like I am. Yesterday, we had the pistol brace rule, die. Today, we had the frames and receiver rule, die. It's all coming crashing down. The pillars of gun control were fractured beyond repair when the Bruin decision came out. Factor in Heller and Caetano, and this gun control as we've known it for the last 45, 50 years is done. It takes time, unfortunately. I know I'm just like you all. I wish it could be done quickly, but our legislative process and our judicial process is set up the way it is for a reason. This is awesome. This is really, really awesome. Guys and gals, please spread the word that ATF is a bunch of charlatans, a bunch of phonies, a bunch of habitual line steppers. This is great, great news. Guys and gals, please like the video, share the video, subscribe to this channel if you want to stay in the know. Turn on the bell notification to let you know when I go live or when I put out new content. This is the third video today. If you haven't seen the other two, please check the channel. Good news is coming out regularly, and I want to bring it to you. I appreciate each and every single one of you. Till we see each other again, be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. I don't care if the ATF don't like it. I don't care if the government doesn't like it. We don't get our rights from the government. We get them from God. We get them from our Creator. We get them just for being alive and being a citizen of the United States of America. Remember, our forefathers died for it, y'all. I'll see you on the next one. Have a fantastic day. Take care.